7, yes, but the relevant part of Sheikh Abdullah's speech is at page 101. PDF 101.
101.
Yes. In the submissions, I just put those paragraphs so that it doesn't waste time. But anyway, I'll refer to that. It's not in addition to anything.
That's 1460.
1460. That's absolutely right.
What is the date of the speech of Sheikh Abdullah?
I'll just give that to you.
This is in the
November,
Constituent Assembly, the J&K Constituent Assembly.
Yes, 5th November 1951. I'm not editing anything new, Malaj. I just, because I didn't want your Lordship's time to be wasted, so I only pointed those paragraphs. There's nothing new in these submissions. That's all.
The agony of this change? The agony of this change?
Yes, the agony of this change, changeover became all the more intense as a result of the position in which the Indian states were left under the Indian Independence Act of the British Parliament. The paramountcy of British Crown, against which the princes had been leaning, it should be, lapsed, and it was made clear that it would not be transferred to either of the succeeding dominions. There were three alternative courses open to them. They could accede to either of the two dominions or remain independent. This gave the prince himself the option to decide the fate of their states. Following the announcement of Mountbatten Plan on June 3, some of the Indian states acceded to Pakistan and some to India by means of instruments of accession executed through their princes. There were also some who entered into standstill agreements with either or both pending finalization of their decision. The betrayal of the interests of the states' people had been expected following the rejections of the memorandum of the National Conference, and we in Kashmir decided to place the issue before the people themselves. This is how our well-known Quit Kashmir agitation began. The National Conference once led the people through a great struggle, and once again the ruler tried to curb it, this time with unprecedented severity. But when the whole people is one and it is not possible to repress them, and they do not stop until they wrest freedom and justice for themselves from the unwilling hands of those about them. The crucial date of India and Pakistan independence therefore came when I and my colleagues were still behind prison bars. The whole subcontinent was in a state of high tension and disturbance. If at that time the head of the state of Jammu Kashmir had even the slightest sense of realism or a proper awareness of the danger lurking in the situation, he would have immediately taken the people into confidence. By associating their representatives with administration, I am sure many of the complications that arose later could have been avoided. Instead of that, the Maharaja government entered into a standstill agreement with Pakistan, and this was accepted without question by that dominion. Now, the next is important. A similar arrangement was suggested to India also, but it is noteworthy that the government of India insisted that it could not consider any agreement entered into by the government of the state valid until it had approval of the people's representatives. While the leaders consistently refused to recognize the vital issue of accession without first securing the approval of his people, the Muslim League and Pakistan government supported the claims of the rulers to speak for their state. The late Mr. Jinnah took the position that after lapse of paramountcy, the princes were completely independent and that they could themselves determine what relations they should have with the two dominions. Throughout the struggles that the people of Kashmir waged against autocracy, we should never forget that the Muslim League leadership had completely dissociated itself from them, and that during the upsurge in 1946, their local party organs had assisted the administration to suppress the movement. At this crucial time, when Pakistan was under the cover of secrecy, perfecting its own plans, and the Dawn, the Muslim League official organ in Karachi, was appearing to the Maharaja to accede to Pakistan on the grounds that he would have great freedom there in India. It was at this stage, taking advantage of the isolation of the Kashmiris from the rest of the world, that Pakistan imposed an economic blockade upon us with a view to starving us to submission. Attempts were made even to excite communal hatred to disrupt our peaceful civic life. Even in the face of such provocations, the National Conference, I'm proud to say, took an objective and democratic stand. Instead, immediately on my release from imprisonment, I clarified the issue of a mass meeting in Srinagar. The first and fundamental issue before us was the establishment of a popular government. our objective might be summarized: freedom first, then alone could free people decide the future association through accession. I also made it clear that the National Conference would consider this issue without prejudice to political friends. So leave that around, Mullahs. Then Mullahs, kindly come to the paragraph. The overwhelming pressure of this invasion brought about a total collapse of the armed forces of the state, as well as its administrative machinery, leaving the completely defenseless people at the mercy of invaders. It was not an ordinary type of invasion, inasmuch as no canons of warfare were observed. The tribesmen who attacked the state in thousands killed, burned, looted, and destroyed whatever came in their way. And in this savagery, no section of the people could escape. Even the nuns and nurses of the Catholic missions were killed or brutally maltreated. As these raiders advanced towards Srinagar, the last vestige of authority, which lay in the person of the Maharaja, suddenly disappeared from the capital. This created a strange vacuum and would have certainly led the occupation of the whole state by Pakistan troops and tribesmen if at this supreme hour of crisis the entire people of Kashmir had not risen like the solid barrier against the aggressor. They halted this onrush but could not stop it entirely, as the defenders had not enough experience training. This is the background on the basis of which the accession took place. Then let us kindly come to this paragraph. When the raiders 1463 were last approaching Srinagar, we could think of only one way to save the state from total annihilation: by asking for help from a friendly neighbor. The representative of the National Conference therefore flew to Delhi to seek help from the government of India, but the absence of any constitutionalities between our state of India made it impossible for her to render us any effective assistance in meeting the aggressor. As I said earlier, India had refused to sign a standstill agreement with the state from the ground that he could not accept such an agreement until it had the approval of the people. But now, since the people's representatives themselves sought an alliance, the government of India showed readiness to accept it. Legally, the instrument of accession had to be signed by the ruler of the state. This the Maharaja did. While accepting that accession, the government of India said that she wished that as soon as law and order has been restored in Kashmir and our soil cleared of invader, the question of the state succession should be settled by reference of the people. Actuated by sincere desire to avoid bloodshed and further conflict, the government of India approached the Security Council in 1948 with a plan against Pakistan. The request was simple. Contention of India was that Pakistan was responsible for the invasion of Kashmir and was continuing to help the raiders who had been employed as mercenaries. And it was further said that legally bound, as India was to clear the Jammu and Kashmir state of raiders, might be constrained to pursue the invaders to their bases in Pakistan, which might lead to still bigger conflagration. India therefore wanted the Security Council to dispose of the case as quickly as possible in the interest of justice. That's how the question of plebiscite Mullahs came before the Security Council. Then Mullahs paragraph, this is the essential background which we must fully take into account. Now I shall indicate some of the considerations which should be kept in view when you, the honorable members of the August Assembly, shoulder the grave responsibility of giving our considered opinion on this issue of accession, which affects not only the present generation of our people, but generations yet to come. Mullahs now skip the following paragraphs and then come to Mullahs, the real character. Mullahs kindly come to paragraph. As a realist, Mullahs, that paragraph. As a realist, I am conscious that nothing is all black and is all black or all white, that there are many facts to each of the propositions before us. I shall first speak on the merits and demerits of the state succession to India. In the final analysis, as I understand it, it is the kinship of ideals which determines the strength of ties between two states. The National Congress has consistently supported the cause of the state's people's freedom. The autocratic rule of princes has been away and representative government have been entrusted with the administration. Steps towards democratization have been taken, and these have raised the people's standard of living, brought about much needed social reconstruction, and above all, built up their very independence of spirit. Naturally, if we accede to India, there is no danger of a revival of feudalism and autocracy. Moreover, during the last 4 years, the government of India has never tried to interfere in our internal economy. The experience has strengthened our confidence in them as a democratic state. The real character of a state is revealed in its constitution. The Indian constitution has set before us the country the goal of secular democracy. Well, we may leave that out, and then leave the other things out. and PDF 562. Speeches. No. Yeah, while the state.
Yes.
Is on 11th August 1952, soon after the Delhi Agreement in July 1952. And whereas in PDF 562 at 1921, he then explains why the provision is temporal. Here I would like to point out, my lords have that paragraph?
Page?
Page 1921, PDF 562.
But after that, actually, we were reading at it goes on to about 1466, where he specifically speaks about the importance of the affiliation with India and accession to India. Because he speaks in terms of, first he speaks about the Indian Constitution.
That's correct.
Second, it's very important from a historical perspective. Sheikh Abdullah refers to the land reforms which were taking place post the First Amendment and the other amendments which took place to the Constitution. He says Pakistan, on the other hand, is a feudal state.
That's correct.
And therefore, our interests would not be protected in a feudal Pakistan as compared to an India where land reforms were taking place. Then he refers to the fact that, India has, of course, the access to the seas and therefore a better, as an economic powerhouse for us to carry on trade through the auspices of India. And this really continues until PDF page 107.
I didn't want to refer to it because it would take too long. Two, it's the background, but we're dealing with the temporary provision. That's why I didn't refer to it. But all that is very important. The reason is simple. Ultimately, what did J&K do? The people of J&K gave to themselves the constitution just as the people of India gave to ourselves this constitution. So central to all this is the will of the people. And therefore, you'll have to compare it to the...
Very interestingly, see how Sheikh Abdullah puts it. He says the most powerful argument which can be advanced in her favor is that Pakistan is a Muslim state.
Yes.
And a big majority of our people being Muslim, the state must succeed to Pakistan. But then he says, this claim of being a Muslim state is of course only a camouflage. It is a screen to dupe the common man so that he may not see clearly that Pakistan is a feudal state in which a clique is trying by these methods to maintain itself in power.
Absolutely. She is right. The point I'm making, Mullahs, ultimately, what's the essence in this matter that your lordships are hearing? The will of the people of a state where the Executive Act of the Union of India, which decimates the will of the people. That's the issue before you. That's what your lordship, because all the three acts of the Union of India are executive acts. 356 deletes the proviso of Article 3. That's an executive act.
Mr. Sibal, look at the foresight of the speaker. He says, these days, economic interests and a community of political ideals more appropriately influence the policies of state.
Absolutely, absolutely.
He had this vision in 1951 when he was speaking about the importance of economic interest, which is what the world is talking about today.
Absolutely.
In a globalized world.
And in that situation, the ruler had no choice. Absolutely no choice. The point I was making is that we are now dealing with three executive acts. One, the 356. Two, change of interpretation in the definition of Constituent Assembly under 367(1) and the abrogation. These are all executive acts. The will of the people is not considered at all. That's the question. Can you delete provisions of the Constitution by an executive act? Can you decimate the Constitution by an executive act? Can you change the Constitution by an executive act? We're not talking about legislation here. We're not talking about parliamentary legislation. That comes after these executive acts, mullahs, are implemented. That's the question. You can't change the Constitution of India as applicable to Jammu and Kashmir by deleting Article 3, the proviso to Article 3. You can't do that through an executive act. You can't change the definition, mullahs, of the Constituent Assembly as legislative assembly through an executive act. Just then I'll come straight away to the issue, mullahs, 1921.
1921.
Yes, PDF, mullahs, 562.
What volume? Which volume is this, Mr. Sibul?
Same volume, mullahs, same volume.
Volume 7.
Yes, same, mullahs, the same speech, mullahs, comes a little later.
19.
Sorry, same speaker comes a little later, mullahs. 11th August is the speech.
1921. PDF page 562.
562, PDF 562. Sentence starting, mullahs, paragraph starting here, I would like to point out. My lords have that?
Just see some problem.
That's correct. That's correct. That's correct.
Yes.
All my lords have it, I'll read it. Here I would like to point out that the fact that Article 370 has been mentioned as a temporary provision, the Constitution does not mean that it is capable of being abrogated, modified, or replaced unilaterally. Kindly mark the words unilaterally, which is exactly what has happened. In actual effect, the temporary nature of this article arises merely from the fact that the power to finalize the constitutional relationship between the state and the Union of India has been specifically vested in the Jammu and Kashmir Constituent Assembly. That's how, mullahs, Parliament understood it in 370. That's how the state understood it. It follows that whatever modifications, amendments, or exceptions that may become necessary, either to Article 370 or any other article in the Constitution of India in their application to Jammu and Kashmir, are subject to decisions of this sovereign body. Since a good deal of confused thinking and uninformed criticism is indulging us in the interest of, I would like to point out here that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with the proviso that they may be extended to such other matters also as the President may by order specify with the concurrence of the Jammu and Kashmir Constituent Assembly. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of the Indian Union therefore clearly envisaged the convening of a Constituent Assembly for the state of Jammu and Kashmir, which would be finally competent to determine the ultimate position of the state in respect of the sphere of its accession, which would be incorporated as in the shape of permanent provisions of the Constitution. This briefly is the position which the Constitution of India has accorded to our state. I would like to make it clear that any suggestions of altering arbitrarily the basis of our relationship with India would not only constitute a breach of the spirit and letter of the Constitution, but it may invite serious consequences for a harmonious association of our state with India. The formula evolved with the agreement of the two governments remains as valid today as it was when the Constitution was framed, and reasons advanced to have this basis changed seem completely devoid of substance. In arriving at this arrangement, the main consideration before our government was to secure a position for the state which would be consistent with the requirements of maximum autonomy to the local organs of state power, which are the ultimate source of authority in the state while discharging obligations as a unit of the federation. Then will us kindly come PDF 648. This is Mir Qasim's statement on 10th November 1952.
Okay.
And this is exactly what I've been submitting before your lordships from day one. A unilateral executive decision cannot change the terms of a relationship which are constitutionally embedded in Article 370. It was PDF 648, page 2007. This speech was given by Mir Qasim on 10th of November 1952. The statement of the Sheikh Mullah, that discussion on his statement continues. In the middle of that paragraph, starting, it is said that the accession of Kashmir with India should be, as far the statement is concerned, there can be no denying the fact that it should not be a dynamic in the sense that we give up our principles. On the contrary, accession should help us in achieving ideals and preserving our autonomy, except, of course, in the objects we handed over to India. Our assembly is competent to make laws and decide the issues, if any, since we are enjoying complete autonomy. We can even frame and amend our constitution. In this collection, we have application under connection. It should be with the application order of 1950 of the Indian Constitution. According to this order, all these powers do not vest in the state. Now, the next is important. We want to develop Kashmir according to the program of New Kashmir. Some people say that it is just possible that in future Kashmir may also become a part of India like any other state and get merged with it. In that case, our internal economy will be reduced to naught and residuary powers will be snatched from us. In this connection, I will submit that the thinking of such people is morbid. These are the vested interests which create such misunderstandings. The representatives of the government of India have not kept any time limit for these residuary powers. This is important. That's why Maharaj 370 talks about instrument of accession and the items in the concurrent list, but doesn't talk of list 2, which is the residuary powers of the state. Therefore, there should be no room for such doubts. We have acceded to India with a definite objective, and I am sure the objective will be achieved. Some interested persons are creating misgivings as regards the autonomy and say that Kashmir has been granted autonomy simply to benefit its Muslim population. But this is a baseless allegation. If the people from outside are not given the right of acquiring property in the state and getting recruited to state services, then it was not the Muslims of this place alone would get benefit, but all communities will also get benefit. Then will us kindly come to the social system which will be set up according to the program New Kashmir will provide equal opportunities of development to all citizens of the state, be they Kashmiris, Ladakhis or Dogras. Now let's skip the rest.
690.
PDF page 694 now. Malas.
Formulate, now that we've seen the speeches, we'd like to formulate the principle which
The principle is, Malas, that an executive act of the Union of India cannot alter unilaterally provisions of the Constitution of India as applicable to the state of Jammu and Kashmir. That's the central.
cannot alter unilaterally
Yes.
the provisions of the Constitution.
Of India as applicable to the Jammu and Kashmir. Including getting rid of the special status given, acceded to by the Union, by the Government of India, and by Parliament in enacting 370 of the Constitution. That's the submission.
Say it's an executive act.
I'll say 356 is executive, 367 definition is executive. These are all executive acts. Parliament came into the picture when the changes had already been done through executive acts. We're challenging that.
As you argued, the process was wrong.
Yes.
Whatever was done. But
Yes.
that is the parliament did it.
No, Parliament accorded approval to the executive acts which unilaterally changed the constitution as it was applicable to the state of Jammu and Kashmir. That's the central question that your lordships will have to decide. Could Parliament have, could the Union of India have done it?
Is it your case that the parliament could have done it?
No, not at all. Well, that also I will answer. Well, let's kindly see. Ultimately, this was a political decision taken in the context of the situation then prevailing. Right? And the complete abrogation of Article 370 must also be a political decision. Well, your lordships will remember Brexit, what happened? In Brexit, what happened? There was no constitutional provision seeking a referendum. But when you want to sever a relationship which has been entered into, you must ultimately seek the opinion of the people. Because people are central to this decision, not the Union of India. It goes counter to the very grain of Article 370.
Mr. Vibal, in a constitutional democracy, seeking the opinion of the people has to be through established institutions,
Agree?
right? So long as a democracy exists, as it does, in terms of a constitutional democracy,
Yes.
any recourse to the will of the people has to be expressed and sought in terms of established institutions.
I agree. So
There's no
either you
question.
do it,
So
either
you cannot-
you do it. Matlab,
You cannot envisage, therefore, a situation like a Brexit type referendum.
Yes.
That's a political decision which was taken by the then government.
Yes.
But within a constitution like ours, there's no question of a referendum.
But this is a political decision that they have taken by unilaterally through an executive order, changing definitions. This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But
That's
therefore, the ultimate question is whether the constitution does or does not interest that authority.
That's correct. That's all that I'm asking, Miller. I'm not asking for anything more.
And which in turn depends on whether 370 is construed as you say, a permanent feature, irrespective of the terminology used, because that is in the context of the changes till the Constituent Assembly was there, or is it something which is capable of being?
Well, let me. That's a much higher level, Mullahs, to which I'm not, in fact, arguing that today. Mullahs, whether it is permanent or it is temporary, let's forget about it. The central question is, can the Union of India, in this manner, terminate that relationship that is constitutionally recognized in Article 370?
We understand.
It may not be permanent. It may be permanent. It may not be. You may change it. You may, you
I
may have.
said in the
as a-
context that that was the argument earlier. So we have come to the next argument, which is the manner in which it is done
That's right.
is flawed accordingly.
It's absolute, absolute. It's a fraud on the constitution itself, according to me. It is politically motivated. It is a political act. These executive orders are political acts. They're not constitutional acts. That's my submission. And whether it is a permanent feature or a temporary feature is really at the moment not an issue. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that. Or have they resorted to that constitutional methodology? If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the Section 92 power was vested in the governor,
Yes.
independent of the Council of Ministers. Step
36,
two,
38,
right. Now,
And
Step
90.
two, right. Step two, the Legislative Assembly is dissolved by the governor under Section 53 without aid and advice.
yes,
3, the proclamation is issued under Article 356.
yes,
You said that the object of the proclamation under 356 to eventually restore democracy
that's right,
and not the decimation of democracy.
right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's
So
also an executive act.
all these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercised them under the garb of 356. That's the submission.
That's
I
right.
think.
Absolutely, I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process
Well,
in
the
1957?
Constitution was adopted in 1957
Yes.
by the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves and said, we don't want, there's no need for this constitution. We want to be a state, a part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken. But my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, I mean, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the 3 options that Sheikh Abdullah spoke about, namely either of joining Pakistan,
Yes.
acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, if this relationship.
That still begs one question.
Yeah.